Hello, my name is Michael Desar, and I prepared this talk entitled the Fraudster Maltster, and it's looking at the case of Viterra Malt Proprietary Limited and Cargill Australia Limited. Ordinarily, I'd be reluctant to use the word fraudster in a presentation, but I can do so with confidence in this particular case because both the primary judge and the Victorian Court of Appeal has upheld the finding or has found that the relevant Viterra parties did engage in fraud. So I can use that pun with confidence. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my practice to Sale Legal Consulting for the last 15 years, and I help companies and individuals with competition and consumer law matters. I also do some expert consultancy work for various legal publishers on competition and consumer law matters, including Wolters Kluwer, CCH, and LexisNexis. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Outline the presentation, start with the background, then look at the grounds of appeal, then the misrepresentations which form the basis of the claim, then the main legal findings, and there the focus will be on consumer law related findings. I won't be going into some of the other areas outside that area of consumer law, and then finally finish with some commentary. Now, the background to the case is back in August 2013, Cargill bought Joe White Maltings, which was owned by Viterra Malt, which in turn was owned by Glencore, which is the ultimate holding company. And Joe White conducted a business as a Maltster, which is a maker of malt for use in brewing or distilling. And it was the largest maltster in Australia. And Cargill went to court alleging that they'd been misled about various aspects of the Joe White business, and the primary judge concluded that Cargill had made out its claims both under the Australian consumer law for misleading deceptive conduct as well as for deceit. And they recovered quite a lot of money. They recovered damages of 168.9 million, which was the difference between what they paid, 420 million, and the judge's conclusion as to the true value of the business acquired, which is 251, plus penalty interest of $124 million. So as you can see, it's almost $300 million in damages and interest. So there's a lot of money at stake. Now, this is an appeal decision I'm looking at by the Victorian Court of Appeal, and I decided to do this case because it's a mere 300 pages long, as opposed to the first instance decision by Elliott, which came down last year, which was 1,810 pages long, comprising of 5,354 paragraphs and 4,826 footnotes. So much better to look at the appeal decision, which I think distills the major issues from the primary judgment. Now, here are the grounds of appeal, and as I said, there were quite a lot of them. Grounds 1, 2, 3, 6, 7, 8, and 10 related to the operation and significance of disclaimers and exclusion clauses. Grounds 3 and 9 related to various warranties provided by the Viterra parties. Grounds 4 and 5 related to the operation of clause 15.4b of the acquisition agreement, which was a confidentiality agreement. Grounds 11 and 12 related to two representations, the pre-completion representations and the other bidders' representations. Obviously, with so much damages being awarded, a lot of attention was focused on that. So grounds 13 to 21 relate to loss and damage. Ground 22 relate to apportionment and also contributory negligence argument. Ground 23 was about interest, and given there was $124 million worth of interest, that's obviously a big issue. And finally, there was ground 24, which related to a refusal by the primary judge to allow the Viterra parties to open their case or reopen their case for a second time. Now, the practices that were the subject of the case, the first was called the reporting practice, and there were three practices called the Viterra practices. And the first related to the process by which Joe White would test the maltings which they had prepared to see if they met the customer specifications. So they tested them in the laboratory, and they would prepare certificate analysis which had various parameters, some of which were essential parameters for the customers, others which weren't. And what they would do is engage in a process of penciling. So they would effectively just change the results in the report so that they met all the parameters which were important to the customers. So just falsify the certificates of analysis so that they met everything the customer had specified was essential to the manufacture of the particular product. Interestingly, they also, or as a judge commented, paradoxically, they sometimes penciled in results that were worse than the results that they found as a result of their testing, and that was because they wanted to not heighten expectations that Joe White could consistently achieve particular results. And so obviously they would do that to non-essential parameters, to just say, well, there's a lot of uncertainty about the way the results come out. And I think this highlights the level of dishonesty that was occurring in the business at the relevant time. It was also a decision by the relevant management to store the written procedures about this penciling process separately to the rest of Joe White's quality procedure manuals, and to make sure that it was not accessible to their auditors. So the International Organization of Standardization auditors would be prevented from seeing these particular documents. And then it was an extensive process, as you could see by those numbers, 4,359 certificates of analysis. 88% contained one or more parameter results which were outside the specification on the laboratory result. So effectively they're altering 88% of all certificates which they're preparing through the laboratory. The second practice was called the varieties practice, and it's a fairly simple issue. Various customers would specify barley varieties which they wanted Joe White to use in their products. And what occurred here was Joe White would regularly not follow those instructions. And as you can see, the conduct is broken up into three types of characteristics. First is where the customer required at least one specific variety of barley be used, and of 4,171 orders, 77% of those orders showed that Joe White used a variety which was not one of the customer's required varieties, and invariably they'd be using cheaper types of barley in order to save money. The second criteria there was where one reported variety was written on the particular certificate analysis. And of the 2,788 unique orders in that category, 88% of the certificates did not record all the varieties that were actually used in the manufacture of the product. So they're hiding varieties of barley from the customers. Again, cheaper, lower quality barley varieties which they were used to make the product. And then the final category is one where they had two requirements. Obviously required a particular variety and didn't want other types of varieties in there. And you could see that of the 2,753 orders there, 88% contained a variety which were not one of the required varieties or left off one of the varieties actually used in the product. So very extensive misrepresentations being run throughout the business for a lengthy period of time. The third Viterra practice was called the gibberellic acid practice, and this is a particular additive which a lot of customers don't want to be used in their particular products, so they banned the use of these products. And it turned out that Joe White used this particular acid in the malt delivered to all of its customers who had prohibited its use, with the exception of one customer. So San Miguel was the only customer who had its wish not to use this particular acid respected. And the practice had been going on for many years, and it continued right up until the completion of the sale. And again, no records were kept of this particular practice, and one surmises that was so that it wouldn't be able to be discovered by Cargill in the due diligence process. Now, there was a further misrepresentation about the sale, and this was related to a couple of phone calls made by an executive of Glencore, Chris Mahoney, to a board director of Cargill, Mr. Koenig, where Mr. Mahoney told Mr. Koenig that his bid wasn't high enough, that there were other bidders higher or in the same ballpark as Cargill, and that they really had to increase their bid by $15 million if they were hopeful to win the Joe White malting business. And that's what Cargill did. They increased their bid to $420 million. It was found by the primary judge that that was a false representation, that the other bids were not equal or higher to Cargill's bid. In actual fact, they were close to $50 million lower than Cargill's bid of $405 million. And the judge found that these representations were demonstrably false. They had forced Cargill, in order to win the business, to bid $15 million more, which is probably close to $70 million more than the next potential bidder. Now, the first issue, I guess, from a consumer law perspective that was looked at was disclaimers, and clearly here relying on the High Court case of Butcher and Lachlan Elder Realty. And clearly it focuses on the public policy reasons behind courts not giving effect to a disclaimer that seeks to exclude liability for conduct which has been found to be misleading, deceptive. So effectively, you can't be relying on an exclusion clause to protect somebody from information that they want to provide to another party which is false and misleading. Clearly, if it's provided on a prospective basis, this opens the way to you just making up lots of different facts about a business in order to sell it. So in this particular case, they relied on the High Court authority to conclude that really to allow exclusion and disclaimer clauses to operate in that context is to undermine the public policy of the Australian consumer law, and also that the concepts of freedom of contract and allocation of risk do not provide sound reasons to allow companies or provide companies with a platform for them to act contrary to law in transactions to sell products. Clearly doesn't permit them to engage in breaches of the Australian consumer law or deceit. They also looked at this argument put by the Viterra parties that they said that they did not vouch for the completeness of any express representations made to Cargill in the process of the sale. And the court concluded that this general assertion that they did not vouch for the completeness of information was not sufficient to affect the implied representation arising from the non-disclosure of these dishonest Viterra practices, which really, if it had not been for these practices, the Viterra business, Joe White Malting, would not have been anywhere near as profitable as it appeared to be. So had the truth been told, the business would have been worth significantly less. So clearly the problem here is they're not alerting the parties to the existence of concealed dishonest practices which have underpinned the financial performance of the business. Disclaimers are really intended to be used to protect the business from the possibility or even the likelihood of an omission, as it says there, due to carelessness, incompetence, failure to appreciate the importance of some matter, or due to a genuinely held belief that some matter does not need to be disclosed. But they can't be used to protect somebody from dishonestly concealing very material facts from another party, in this case from a purchaser of a very large business. In relation to exclusion clauses, the Court of Appeal upheld the primary judge's conclusions there as well, that it is a question of the matter of public policy that liability for fraud, deceit, contraventions of the Australian consumer law not be excluded by exclusion clause. And there, as it says in the second part, requiring a counterparty to enter into a release at the commencement of commercial dealings cannot provide a mechanism for releasing the party or absolving them absolutely from subsequently engaging in misleading, deceptive conduct. So you're getting a prospective exclusion, which, as you can imagine, if you're going to be protected from any misleading, false, deceitful statements you're going to make in the future, it creates a very big incentive to make many such fraudulent, deceitful and misleading representations to the other party. Now, there was a helpful little summary of the authorities, and it's called the Summary Authorities for Disclaimers, but really you can see it as being for disclaimers, exclusion clauses, and other types of similar type of clauses. So the first point is that contractual provisions cannot absolve a party from liability for their own fraud, which is a pretty obvious point. Contractual provisions might be effective to absolve a party from liability for the fraud of a party's agent. However, you can't do that using very general words. Rather, you have to exclude liability in very clear and unmistakable language. So, whilst it's possible to exclude liability for a fraud of an agent, you have to spell it out so clearly that you're doing that it's going to probably trigger a few alarm bells in the minds of a prospective purchaser. Thirdly, no representation clauses, no reliance clauses, and other forms of disclaimers can have an evidentiary effect which negates an integer of liability in relation to misleading deceptive conduct. So they may not get you off the hook in most cases in terms of liability, but they may have some evidentiary value. Now, the potential for those type of clauses to have some evidentiary value has to be assessed in the context of the conduct as a whole, a pretty obvious point. Fifthly, exclusion clauses which purport to absolve liability under the ACL for misleading conduct which has occurred and has caused loss cannot have effect in accordance with the terms where they are contained in a contract which the claimant has been misled into entering. So that's an interesting observation, that you're trying to get the benefit of an exclusion clause, but had it not been for that particular exclusion clause, they wouldn't have entered into the relevant contract. And then finally, although a person cannot contract out of liability for fraud or deceit or out of certain statutory rights or entitlements, it remains possible to compromise a dispute about those issues. So it's important to draw a distinction about excluding or disclaiming liability for misleading conduct, fraud, deceit, and compromising a claim in those areas, which is permissible. Now, there's also a confidentiality deed, which Viterra argued prevented them from being liable for misleading deceptive conduct, and it seemed to exclude the remedy for damages under 236 of the Australian Consumer Law. And again, they believe that it would be contrary to public policy to allow such a exclusion in the confidentiality deed. It would be contrary to public policy. As you see there, it says not to pursue an action for damages would, in our opinion, undermine the efficacy of Section 18 and the purposes of the ACL. And they note this ability to permit a prospective exclusion clause would create this distinction, which they believe is unprincipled, between waiving liability for past misleading conduct and for future misleading conduct. And there's no real sound policy reason for drawing this distinction. Also notice that clause 10.3 of the confidentiality deed did not seek to compromise a claim or potential claim for misleading deceptive conduct. Rather, it sought to prevent liability ever arising, and focusing again on the public policy reasons why that can't be allowed to be enforced. And there they note, they will go through a lot of cases in this particular judgment, discuss all the different High Court cases, but they conclude there that the Henjo High Court decision was correct in concluding that liability for misleading deceptive conduct cannot be ousted by private agreement, and also the IOOF case was correct to conclude, again, the public policy principle applies to a clause in the contract which was not itself induced by misleading deceptive conduct. That's probably an important distinction to bear in mind. And then ultimately they concluded that this particular clause 10.3 of the confidentiality deed was unenforceable to the extent that it sought to exclude the ability to recover damages under the Australian Consumer Law. The reliance point was raised, and the primary judge concluded, and it was upheld by the Court of Appeal, that there was little doubt that if Cargill had been informed of all the Viterra practices and all the relevant documents that existed showing what was really going on, then they would never have entered into the acquisition agreement to acquire the Joe White malting business. So clearly there was a strong reliance on the truth of the information provided. There was also this interesting issue about these contractual claims, and so what occurred is Cargill bought Joe White and then sold it to another party, and that sale actually extinguished any contractual claims which Cargill had. So they concluded, the primary judge was right to conclude that because the business had been on-sold in 2019, clause 15.4b of the acquisition agreement did operate to extinguish Cargill's contractual claim. However, that did not exclude Viterra's liability under the Australian consumer law for deceit, which all survived the on-sale of the business. Now, most of the loss and damage, the key case there is probably Berry and CCL Secure, although it does support the earlier High Court decision of Potts and Miller. And there it's talking about the ability of a claimant who's induced by deceit and what damages they can recover. And the decision in that case was that actual damage directly flowing from the fraudulent inducement can be recovered, but independent, extrinsic, supervening, and accidental losses cannot be recovered. So it's a pretty obvious principle. So again, the Court of Appeal summarised the main issues that arise in relation to the assessment of loss and damage, I guess both under Australian consumer law, but under fraud and deceit as well. But here it's talking about the measure described by Justice Dixon in Potts versus Miller is probably the starting point in working out loss and damage, and that's the difference between the price paid and the true value at the time of the acquisition. So that's well-established principle, and it's usually applied. True value is to be determined objectively by reference to what price freely contracting, fully informed parties would have offered and accepted, not according to what either or both the parties to the contract believed it would obtain. So I guess a bit of a counterfactual. Here you might be looking at other bidders, what they would have acquired the business had they known all the relevant facts. True value is not the same as market value. Events subsequent to the acquisition may indicate or reflect the true value and thus measure of the loss earlier suffered. So I guess you don't just look at the price paid at the relevant date, you look at subsequent events. Additional consequential losses over and above those calculated by the Potts v. Miller approach may be recoverable in appropriate case. So you're just not looking at the difference between the real value of the assets at the date of the acquisition and the price paid for it. You've actually got to consider other numbers that have arisen subsequent to the purchase. One reason why the Potts v. Miller approach is generally adopted is the desirability of separating out losses resulting from extraneous factors in the later history of the asset. So you don't want to necessarily be considering all these subsequent losses and factors which may not have a lot of bearing. I guess the other approach that's looked at is the left-in-hands approach. And this is an approach which the benefits of a subsequent resale of a business are taken into account. So clearly there was an issue in this particular case, given that Cargill had sold the business, whether the left-in-hands approach was better. And under this particular approach, damages are calculated by looking at whatever is, I guess, left in the purchaser's hands after the event and at the time that the matter is before the court. And clearly they're entitled to all their losses, but you've got to take into consideration any benefits that have been received by the company in the time, or losses in the time that they have owned the business. And they make the final point that it's not a binary choice between Potts and Miller approach and the left-in-hands approach. There could be other approaches that are appropriate in a particular case. You can't say that one's right, one's wrong. You really got to look at all the facts and determine which is the best approach. Here, the Potts and Miller approach was considered to be the correct approach to take. So under the approach, they wanted to place Cargill back in the position it would have been in if it had not been misled, which is not paying the price of 420 million and what it actually acquired, the value of what it actually acquired. And based on that approach, and there was some expert evidence put on in relation to this issue, the Court of Appeal upheld the primary judge's conclusion that Cargill should recover $168 million, which was the difference between what they paid, $420 million, and the true value of the assets acquired. So this is really looking at if things were being done, I guess, by the book without these illegal practices, the value of the business would have been significantly less at $251 million. A couple of arguments were raised at the end of the judgment, which I guess have some relevance to the Australian consumer law, proportionate liability and contributing negligence. So the Viterra parties argued that their liability should be reduced due to the proportionate liability provisions under Section 87 CD of the Australian consumer law, which are very untraversed part of the legislation, and also contributory negligence under 137B. And the problem with the argument on proportional liability is clearly the exclusion in Section 87CC about intentional or fraudulent conduct. So here there's no proportional liability able to be claimed because the Viterra parties had engaged in wrongdoing intentionally and fraudulently, and that's specifically excluded under the apportionment regime under the legislation. And as I said earlier, the court made strong findings of fraud, not simply against the Viterra parties, but also against Glencore for its role in the sale. So there were strong findings of fraud against both of those companies, which meant any proportionate liability claim could not be successful. And then the claim about contributing negligence is a very weak claim, and it's not dealt with in much detail, but fundamentally the court decided that Cargill did not fail to take reasonable care in protecting its own interests. It had no way of really discerning the falsity of the information provided to it. So just some final commentary. This is very dishonest conduct. It's quite embarrassing reading this conduct by an Australian company, admittedly owned by foreign corporations, but very dishonest conduct, a lengthy, extensive period of misleading consumers, big consumers, beer companies and other distilling organisations, misleading the auditors, and quite a concerted approach to misleading the buyers, not just Cargill, but all the buyers in the business, including not providing proper documentation, obviously not putting everything relevant in the data room. It's quite remarkable how extensive the dishonesty was. There was clearly a conscious effort to mislead the buyers. I don't know quite why people hope to get away with that, because ultimately when you sell a business to somebody, they're going to discover all the problems with it. And the good thing about this case, while I don't think it establishes much new law, it does reinforce that these type of exclusion clauses, where they are aimed at hiding not just fraudulent, deceitful conduct, but misleading conduct, won't be enforced by courts. You just wonder how such widespread practice could be hidden for so long, and how they could be hidden so extensively in the course of a due diligence process. I think a lot of people would have had to be in the know as to what was going on. So there must be a lot of individuals who were part of this deception, although only a few people are mentioned in the relevant cases. Some of the arguments made in this claim as inclusion clauses seem to me to lack a lot of merit. I don't know why they were put forward. They weren't going to win. I think the ones on proportionate liability and contributing negligence are particularly weak, but I guess when you're dealing with a $300 million claim, you throw everything in the mix and hope something sticks, and nothing stuck at all in this particular case. And I think it's likely there'll be a special leave application of the High Court, given how much money is involved. Like, it's huge amounts of money. I don't think they'll have any success in the High Court. There might be some clarification on some of the law if it goes to the High Court, but I'd be very surprised if the Viterra parties had success at the next level, although I think there's really no argument that they'll have a go. So that's all I have. Hopefully that's been helpful. I guess you don't want to read 300-page judgments if you can help it. Definitely don't want to read 1,800-page judgments. So hopefully this does set out the major issues, and to make a bad pun, distills the major learnings from these cases. And if you have any questions, feel free to give us a call or send me an email. Bye-bye.